My husband filed for divorce. I only want our son, he said, not even looking at me. You can keep the house, the cars, the accounts, everything else. My lawyer, Diane Foster, leaned so close I could smell her coffee breath. Sarah, she whispered, do not agree to this. I kept my eyes on the water stain on the courtroom ceiling, the one shaped like a lopsided heart, and I said, fine, let the judge hear exactly what he's asking for. The room went dead silent. Somewhere behind me, a woman I didn't recognize shifted in the gallery, and the sound of it seemed too loud in all that quiet. Diane's pen stopped moving. I have spent 22 years learning how to read what's underneath things. Old letters, faded ink paper that's been altered so carefully you'd never know unless you knew exactly where to look. I'm a paper conservator at the Fairview Historical Society in Fairview, Massachusetts, and along the way I've learned to spot forgeries. A false signature has a rhythm to it, a real one doesn't. I had been reading my husband Ethan Whitmore the same way for 4 months, and what I'd found underneath him was not a man who loved our son so much he'd give up the house, the cars, the joint accounts just to have him. It was a man who needed something only custody could unlock. Ethan sat 2 chairs down at the plaintiff's table, hands folded like a man doing something noble. His attorney Wayne Carell had the calm posture of someone who thought the math was simple. Sarah keeps the marital assets. Ethan gets Caleb. Don't reject it yet. I'd told Diane weeks earlier, the first time Ethan's proposal came through in writing. Let him believe the court will consider it. Mr. and Mrs. Whitmore. Judge Alvarez said, looking over her glasses, I want to be sure both of you understand the terms of this proposed stipulation. Under this arrangement, Mrs. Whitmore would retain the marital home, both vehicles, and the joint investment accounts. Mr. Whitmore would retain Whitmore Building Solutions and its associated business assets. Mrs. Whitmore is also agreeing that Mr. Whitmore will receive sole legal custody and primary physical custody of your son, Caleb, meaning Caleb would live primarily with his father, and Mr. Whitmore would hold authority over major decisions in Caleb's life. This is a proposed agreement. It will not become a final order today. I still need to review it before entering it into the record. Tight. I understand, Your Honor, I said. I did. That was the thing nobody in that room understood, yet not even Diane, not fully. I understood far better than anyone, including Ethan himself, who believed he was the only one who knew what was really at stake in those words' authority over major decisions. Across the room, Ethan's shoulders had the ease of a man who thought he'd already won. He didn't glance at the gallery once, which told me better than anything else could have how little he understood about what was coming. Ethan did not want our son for the reason everyone else in that courtroom believed. And by the time this hearing was over, the room would understand exactly why. But I'm getting ahead of the story. To understand how I ended up in that courtroom agreeing to a plan that could have cost me my son, you have to go back to the beginning. Not the wedding. Not even the good years, because there were plenty of those. And I don't want you to think this is a story about a marriage that was rotten from the start. It wasn't. It's a story about how something solid for a long time can quietly start to fail one hairline crack at a time, until the day it doesn't hold anymore. Conservators spend less time admiring beautiful things than people imagine. Mostly we find what's wrong with them. Foxing at the margins of an old letter. Iron gall ink eating slowly through paper from the inside. After 19 years in that line of work, you can't turn the eye off. You notice the grout going gray in your own kitchen and file it away monitor, don't intervene yet. That's what I did with my marriage for a long time. Ethan and I had been married 18 years. He ran Whitmore Building Solutions, a construction supply company his father started out on Route 9. I met him at 26, interning at the Fairview Historical Society, restoring town records in the building next door to a renovation site he was hauling lumber for. We dated for almost 3 years before he proposed. Long enough, I used to joke that half our friends had given up waiting for it, and I married him at 29. We had Caleb 3 years after that, when I was 32. For a long time, our life was plain and steady dinner at 6 Sunday hikes at the reservoir, Caleb's baseball games, where Ethan screamed himself hoarse from the bleachers. For most of those 18 years, I would have told you Ethan was a good husband, if an occasionally distracted one. He coached Caleb's Little League team for 6 seasons, even though he didn't know the infield fly rule until our neighbor explained it to him at a barbecue. He drove 2 hours each way to help my mother move a couch the year my father got sick. He wasn't a man who forgot birthdays or disappeared into work on purpose. Whatever went wrong later didn't erase any of that. And it took me a long time to be able to hold both truths at once, that he had been genuinely good to us, and that he had also eventually decided we were expendable in a way he never had the courage to say out loud. The first crack wasn't dramatic. It rarely is. It was a Tuesday in early spring. I'd stayed late cataloging a donated collection of Revolutionary War-era letters, and when I got home around 8, Ethan was in his study door, mostly closed, voice low, in a way that didn't match his usual booming tone with vendors and old friends. "No, I told you not yet," he was saying. "Just give me a few more weeks." I didn't think much of it that first time. Businesses have bad quarters. Vendors call late. But the calls kept happening always after Caleb had gone up to his room, always with the door pulled to but never quite shut, as if some part of Ethan still wanted to be caught or still believed he wasn't really hiding anything yet. Then came the new habits. A gym membership after 18 years of never once mentioning wanting one. 2 expensive suits for a man who wore flannel and steel-toed boots to a lumber supply office. A phone angled away from me at dinner out of some reflex he probably wasn't even aware of. None of it on its own was proof of anything. That's the thing people don't understand about deception. It rarely arrives all at once. It accumulates the way water damage does, one small intrusion at a time. Until one day you press your thumb against the drywall and it simply gives. I didn't confront him. In my line of work, you don't yell at a damaged document and demand it explain itself. You examine it under raking light thrown across the surface at a low angle, so every dent and crease and inconsistency stands out, and you let the evidence tell you what happened in its own time. I started doing that with my own husband, more out of habit than suspicion at first. The real turning point came on a Thursday evening in early June. I'd come home early, an afternoon appointment had canceled, and found Ethan in the garage hunched over a banker's box on the workbench, sorting papers with the quick, guilty efficiency of someone who doesn't want to be caught mid-task. He startled visibly when I said his name, which told me more than anything he actually said. "Just old business files," he said, sliding the lid half over the box, his hand resting flat on top of it like he was holding something down that wanted to spill. I let it go that night the way you let a hairline crack in drywall go, telling yourself it's only settling. I've thought since about how much earlier things might have gone differently if I'd simply asked him directly that same evening what was actually in that box. I don't know that it would have changed anything. Ethan had already made a decision by then. I was only starting to catch up to it. 3 days later, paying bills at the kitchen table, I opened an envelope that had been sitting unopened in a drawer where Ethan kept old warranties. It was from Bradbury and Vance Trust Management, addressed to Caleb Whitmore, care of Ethan Whitmore, custodial parent designee. I didn't understand what I was looking at yet, but I understood enough to know it was the first real crack in the wall, the kind you can't paint over and call settling anymore. My father wasn't wealthy in the way people picture wealth. He ran a small printing business for 40 years and invested slowly, carefully, the way he did everything. When he died 6 years ago, he left a trust for Caleb, a little over $300,000, meant to mature when Caleb turned 25. What I hadn't known was a clause his estate attorney had written years earlier, back when Caleb was a baby, meant to protect the trust if both parents died at once. The clause stated that if Caleb's primary physical custody changed before he turned 18, the new custodial parent could petition Bradbury and Vance to be named co-trustee alongside the corporate trustee, with the power to request distributions for the minor's benefit subject to the trust company's approval. Not full control, not a blank check, but a foot in the door that hadn't existed before. I called Bradbury and Vance under the guise of a routine beneficiary inquiry and learned 2 things that changed everything. First, the co-trustee clause was real and current. Second, and this was the part that made my hands go cold at the kitchen table, Ethan had already filed a preliminary petition 3 weeks earlier, requesting recognition as co-trustee contingent on a pending custody order, along with a proposed distribution request for $180,000. Structured as a purchase, the trust would buy a property to serve as a suitable residence for the minor beneficiary's primary care, with title to be held in the trust's name for Caleb's benefit. On paper, that looked almost responsible money going into an asset held for Caleb, not simply handed over. I asked the trust officer carefully whether the property had already been identified and appraised. She read me an address on Larkfield Road and a purchase price that struck me, even without any real estate background, as high for that stretch of town. I looked up the property that night. It wasn't listed for public sale. It was owned by an entity called Meridian Grove Consulting, LLC, registered 8 months earlier with a Providence law office, listed as its registered agent, and an independent licensed appraisal later valued it at nearly $40,000 less than the price named in Ethan's petition. I sat with that for a long time before I understood the shape of it. The trust wouldn't simply be handing Ethan cash. It would be buying a house in Caleb's name from a company Ethan controlled at a price padded well above what the property was actually worth, and the difference once the sale closed would sit quietly inside Meridian Grove, available to him in a way a direct trust withdrawal never could have been. It was a more patient kind of theft than I'd first assumed, but a theft all the same. I looked at what else I could find mail that came through our own front door statements for Whitmore Building Solutions, with overdue vendor invoices, a maxed line of credit, a payroll account that had come dangerously close to bouncing twice that spring. A business bleeding money quietly enough that Ethan could still show up every morning in a pressed shirt and pretend even to himself that it was under control. I want to be fair to him here because I've had a long time to think about how this must have started, and I don't believe Ethan woke up one day and decided to steal from his son. I think it happened the way most of these things do, in small defensible steps. I think he told himself the first time that it was a loan, that he'd put it back before anyone noticed that Caleb would never actually need the money before 25 anyway, and that saving the business their family name was printed on was, in some warped accounting of loyalty, also something he was doing for Caleb. I think somewhere in the last year, the distance between borrowing and taking simply stopped feeling like a line he'd crossed, because he'd been inching toward it for so long he could no longer see it behind him. I understood much later why he'd been willing to trade away the house, the cars, the accounts so easily. Nora's attorney's disclosures eventually surfaced a conversation Ethan had over the summer with a junior officer at Bradbury, and Vance informal off the books, the kind of conversation that never gets written down until it becomes evidence in a fraud referral. The officer had apparently told him in general terms that a residence request from a custodial co-trustee, paired with clean-looking paperwork, would likely move through review without much friction. Ethan hadn't been gambling blind. He'd been told by someone who should have known better that the plan would probably work. That's a different kind of recklessness than desperation alone. It's the recklessness of a man who believes he's already found the seam in the wall. None of that made it acceptable. It only made it human in the specific disappointing way that most betrayals turn out to be human, once you look closely enough at them, not monstrous, just small and dressed up in justifications. A person tells himself in the dark so he can still look at his own reflection in the morning. I didn't confront him. I opened my laptop and started a file. I titled it simply, Trust. I didn't go to Diane with all of it right away. When Ethan finally said the word divorce on a rainy Sunday in July, he delivered it like a business proposal. "I think we both know this isn't working," he said. "I want this clean. You keep the house, the cars. I just want Caleb." "Okay," I said, and watched something cross his face that wasn't quite triumph and wasn't quite relief, closer to a man who'd braced for a much harder fight and found the door standing open. I met Diane the next morning. I laid it out for her: the trust letter, the co-trustee petition, the Larkfield Road property, the LLC. Diane set down her pen. "Sarah, this isn't just concerning. This is a father using a custody claim to position himself for what could be trust fraud. We take this straight to the court. We petition to freeze the trust's distribution authority, and we oppose the custody request outright. If we do that today," I said, "he has time to move money before anyone can trace it further. Right now he thinks I don't know anything. I want to keep it that way a little longer, long enough to know exactly where the money's going and who's helping him move it. And if the judge simply approves the stipulation before we're ready, Diane said, Sarah, I am not going to let you sign away primary custody on a bet. I'm not asking you to let anything happen quietly, I said. I'm asking you to help me build this properly so that when we do go to the judge, nothing about it can be waved away as a misunderstanding. We spent that meeting mapping out what a responsible version of my instinct actually looked like. Diane would file the custody stipulation as a proposed agreement, not final standard practice, giving us time before a judge signs off. At the same time, she would quietly retain a licensed forensic accountant to formally review the business and trust records once we had enough documentation to make that retention worthwhile. And she would file an emergency motion asking the probate court to place a temporary hold on any distribution from Caleb's trust, with the supporting financial exhibits filed under restricted access to protect Caleb's private information. You understand the risk is still real, Diane said. A proposed stipulation isn't nothing. Judges do sometimes rubber stamp uncontested terms if nothing's raised in time. Then we make sure something's raised in time, I said. The months that followed ran on 2 tracks at once. In August, Ethan filed the paperwork relaxed and confident, believing he'd negotiated an easy exit. Diane filed our stipulation in response and separately filed an emergency motion asking the probate court to place a temporary administrative hold on any distribution from Caleb's trust while his co-trustee petition was under review. The motion's supporting financial exhibits were filed with restricted public access, since they contained Caleb's private account information, but Ethan's attorney was still served proper notice of the filing itself as the law required. He knew the motion existed. He had no way of knowing yet how much of it we could actually prove. In September, I found the photographs. Caleb had left his tablet on the counter, logged into a family photo account that synced automatically from Ethan's phone. A new album appeared a weekend in Newport. Ethan on a hotel balcony. Ethan across a restaurant table from a dark-haired woman in her mid-30s dressed like someone used to reviewing documents for a living, a posture I recognized because it was mine. I didn't know her name yet. Diane did within 4 days after cross-referencing the registered agent listed on the Meridian Grove filing, Marsh and Kellerman, a small Providence firm specializing in entity formation. A junior associate named Nora Bellamy had signed the incorporation paperwork. I want to talk to her, I said. You're not going to, Diane said. I am through channels that don't put you anywhere near a harassment claim. She sent Nora a formal preservation letter and a subpoena request for any records related to Meridian Grove Consulting standard procedure for a party who might hold discoverable evidence. Nora didn't respond directly. She retained her own attorney within a week, which told us more than anything, that she understood exactly how much trouble the filing could mean for her license if this ever became a fraud case instead of a family court footnote. We later learned through her attorney's disclosures most of what had brought her to that point. Nora Bellamy was 34, 3 years out of a difficult divorce of her own, and by every account I eventually saw genuinely good at her job, meticulous, a little guarded, the kind of associate senior partners hand the filings that need to be done exactly right the first time. She'd met Ethan the previous spring at a regional contractors conference in Providence, where he'd given a talk on supply chain resilience that, according to her own statement, was the most confident I'd ever seen a man talk about something that turned out to be falling apart underneath him. She hadn't known when she signed the LLC paperwork that November that the man she'd been seeing for 8 months was married with a 15-year-old son. He'd told her he was separated, waiting out a slow, amicable divorce for financial reasons. She found out the truth in July, the same week Ethan filed against me, when a mutual acquaintance from the conference circuit mentioned in passing how Ethan's boy was doing. She said she went home that night and didn't sleep, running back through 8 months of a relationship she'd believed was honest, at least in its broad shape, if not its timing. By her account, she nearly ended things with him then. What kept her in it a little longer, she told her own attorney, was a stubborn hope that the divorce really was already moving forward, that she hadn't been quite as deceived as it felt, until an email arrived in early September forwarded from Ethan's business account, instructing her firm to expedite the Meridian Grove paperwork, ahead of the custody order clearing, so a first trust distribution could move before the quarter closes. She said that was the sentence that changed everything, not the affair, the math. She understood reading it that she wasn't an inconvenient complication in Ethan's life anymore. She was a tool he intended to keep using, and the paperwork bearing her signature could someday sit in front of a judge with her name on it and no one else's excuse attached. I never spoke to Nora directly. I didn't need to, and I'm honestly not sure what I would have said if I had. That part of it belonged to Diane, and she handled it the way she handles everything patiently in writing, building a record instead of a confrontation. What I did instead in those same weeks was harder in a different way. I sat in Caleb's room one night after he'd fallen asleep over his homework, watching him breathe with his algebra book still open on his chest, and I let myself cry in the car afterward in the driveway, engine off, for almost 20 minutes. Some nights the plan felt less like strategy and more like gambling with the one thing I couldn't survive losing, and I hadn't told a single person, not even Diane, how many of those nights there actually were. I never let Caleb see it. But I stopped pretending, at least to myself, that I was as calm as I needed everyone else to believe I was. There was a Saturday morning in early October when Caleb found me at the kitchen table with 3 folders, spread out a spreadsheet of dates and transfers, glowing on my laptop screen. He stood in the doorway in his pajama pants, hair flattened on one side from sleep, and asked quiet, "Is that about Dad?" I almost lied. Instead, I said, "Yes, it's some things I'm trying to make sure a judge understands correctly. Understands about what." I closed the laptop not to hide it from him, but because I needed to look at him while I answered. "About money that belongs to you," I said. "I'm making sure nobody spends it without you knowing." He was quiet for a moment. Then he asked the question I'd been dreading since July. "Are you and Dad splitting up because of me?" "No," I said. "Never because of you. Not one day of this is your fault, and I need you to actually believe that, not just hear me say it." He nodded, chewing the inside of his cheek the way he'd done since he was small whenever he was holding something back. "He keeps saying he just wants to make sure I'm taken care of," Caleb said. "Like that's supposed to make it sound better." I thought carefully about how to answer, without putting him in the middle of something that was at its core an adult failure, and not his to carry. "Whatever your father believes about that," I said, "I need you to know I'm not going anywhere from your life. Not for one day. It doesn't matter what any piece of paper ends up saying." "Okay," he said quietly. "I believe you." Then, after a pause so soft I almost missed it, "I don't want to live somewhere else. I don't want to be the reason you lose the house or anything, but I don't want that." I didn't tell him then that the house wasn't actually at risk, that the version of events he'd absorbed from overhearing his father wasn't quite accurate. I only told him that his preference mattered, and that people whose job it was to listen to kids in situations like his would be asking him gently what he wanted, and that he should tell them exactly what he'd just told me. That happened 2 weeks later. Given the financial questions Diane had already raised, the court appointed a guardian ad litem, something a Massachusetts family court judge can order whenever an independent assessment of a child's best interests is needed, rather than relying solely on what either parent claims. Her name was Patricia Nunes, a soft-spoken woman in her 60s who met with Caleb twice alone at his school counselor's office, and separately interviewed both Ethan and me, reviewed Caleb's school records, and spoke briefly with his homeroom teacher. Diane later told me Patricia's report noted in careful, neutral language that Caleb had expressed a clear and consistent preference to continue living primarily with me, citing stability, proximity to friends, and, in his own words, which the report quoted directly, not wanting to be the reason anyone loses anything. I hadn't coached him. I'd been careful almost to a fault not to put that weight on him at all. It turned out he'd been carrying it anyway, quietly, the way children do when they think the adults around them are too fragile to hear it. By late October, we had what we needed: the trust correspondence, the co-trustee petition, the inflated purchase price on the Larkfield Road property, compared against an independent licensed appraisal, Nora's attorney's disclosure of the September email, and a forensic accountant's preliminary written report, now formally retained by Diane's office, outlining a pattern of transfers from Whitmore Building Solutions into Meridian Grove Consulting that didn't correspond to any invoiced service. The hearing was scheduled for November 14th. The night before, Diane called me at 9, later than she usually allowed herself to work. "Nora's attorney confirmed it an hour ago," she said. "She'll testify. I want you to understand what that means, Sarah. Once she's on the record, there's no controlling what happens next. This stops being something we manage quietly. It becomes something the court and eventually maybe the state decides how to handle." "I understand," I said, and I did, though understanding it and feeling ready for it turned out to be two very different things. After we hung up, I sat at the kitchen table for a long time without turning on the lights, listening to the refrigerator hum the same sound I'd fallen asleep to for 18 years, and I let myself feel fully for the first time since June how frightened I actually was, not of losing the house or the accounts, but of some clerical accident. Some judge having a distracted afternoon, some version of tomorrow where the paperwork I'd built so carefully simply wasn't enough. I didn't sleep much. Around midnight, I heard Caleb's door open down the hall and then his voice quiet from my doorway. "Mom, you still awake?" "Yeah, bud." He came and sat on the edge of the bed the way he used to when he was 7 and scared of a thunderstorm. "Tomorrow's the court thing." "It is. Are you scared?" I could have lied to him. I'd been careful all these months about what I let him see, but something about the hour, the dark, the fact that he'd asked so plainly made me answer honestly instead. "A little," I said. "But being scared and being sure are two different things. I'm scared about tomorrow. I'm sure about you." He nodded, and after a moment he said, "I told Ms. Nunes I want to stay with you. I hope that was okay." "It was more than okay," I said, and my voice cracked on the last word in a way I hadn't planned. He hugged me quick, and a little embarrassed the way 15-year-olds are about affection, and went back to bed. I lay awake another hour after that, and for once I didn't try to talk myself out of how much was riding on the next morning. The morning of the hearing, I stood in our kitchen one last time before leaving. I ran my hand along the door frame, where Caleb's height had been marked in pencil every birthday since he was 3. Even if the house stopped being mine someday, I thought those marks would still belong to these walls. At the courthouse, Ethan looked composed, almost cheerful in a gray suit that fit him better than anything I remembered him owning before that year. Wayne Carell sat beside him with the easy posture of a lawyer who believed his side of the table had already won. I sat with Diane across the aisle, my hands folded so tightly in my lap that my knuckles had gone pale by the time the bailiff called the room to order. Judge Alvarez read through the stipulation terms in a steady voice, the same terms she'd outlined at the start, unchanged: the house, the vehicles, and the joint accounts to me, the business to Ethan, sole legal and primary physical custody of Caleb to Ethan pending her review. "Mrs. Whitmore," Judge Alvarez said, "are you asking this court to approve these terms as written?" "I'm asking the court to review the proposal, Your Honor," I said. "But before any ruling is entered, my attorney has evidence directly affecting Mr. Whitmore's motive and Caleb's best interests." My hand resting on the table was not as steady as my voice. I want to be honest about that. Some part of me, even having built the entire case myself, still understood that a judge could in theory simply approve what was in front of her and move on before anyone said another word. Diane rose beside me. "Your Honor, I'd like to bring to the court's attention an emergency motion filed on October 3rd concerning the pending trust petition, along with supporting financial exhibits filed under restricted access. I'd also like to call a witness whose testimony bears directly on it." Wayne stood jaw tight. "Your Honor, Ms. Bellamy's name has been on our witness list for weeks. My client and I were not informed she'd agreed to testify or what she intended to say. Ms. Bellamy retained independent counsel only 2 days ago, Your Honor," Diane said. Her decision to cooperate was communicated to this office and disclosed to opposing counsel as soon as it was confirmed consistent with the court's disclosure rules. Judge Alvarez glanced at her clerk, who confirmed the filing date, and nodded for Diane to proceed. "I'll allow the testimony, Mr. Carell. You'll have the opportunity to cross-examine." The petitioner calls Nora Bellamy. Ethan turned around fully in his chair. I watched the color leave his face the moment he saw her rise from the gallery. Nora Bellamy was sworn in by the clerk, her voice thin but steady as she stated her name for the record. Ms. Bellamy. Diane said, "What is your professional relationship to Meridian Grove Consulting, LLC? I'm an associate at Marsh & Kellerman in Providence. I filed the entity's formation paperwork last November on Mr. Whitmore's instruction." "And your personal relationship to Mr. Whitmore?" A pause. "We were seeing each other. I didn't know until this past July that he was married with a son." Wayne was on his feet. "Your Honor, relevance?" "Overruled for now," Judge Alvarez said. "Continue, Ms. Foster." Diane held up a printed page. "Ms. Bellamy, do you recognize this email dated September 9th sent from Mr. Whitmore's business account to yours?" Nora looked at it briefly. "Yes." "Would you read the highlighted portion for the record?" Her voice shook slightly. "Once custody clears, Bradbury will recognize me as co-trustee. Then we can move the first distribution before the quarter closes." The courtroom, which moments earlier had felt like a routine hearing on paperwork, went taut. Wayne stood quickly. "Your Honor, may I have a moment with my client before this proceeds further?" "You may have 5 minutes, Mr. Carell," Judge Alvarez said. "Not longer." Ethan and Wayne conferred in urgent, lowered voices. When the hearing resumed, Wayne rose with some of his earlier composure rebuilt around him like a hastily patched wall. "Your Honor, my client acknowledges sending correspondence to Ms. Bellamy regarding the trust petition, but maintains that any distribution request was intended entirely for the benefit of the minor child, consistent with the trust's stated purpose, and that the Larkfield Road property was under consideration as a potential family residence before those plans changed." "Then perhaps Mr. Whitmore can explain." Diane said, "Why an independent licensed appraisal values the Larkfield Road property nearly $40,000 below the purchase price, named in his petition to Bradbury and Vance, and why the seller of record is Meridian Grove, consulting a company Mr. Whitmore formed and controls." Wayne looked down at his copy of the exhibit, flipping to the page Diane had referenced. "I watched him find it. Watched his shoulders drop half an inch, the particular stillness of a man realizing there was no clean way to explain around a fact instead of through it. Mr. Whitmore." Judge Alvarez said, turning to Ethan directly, "Did you send the email Ms. Bellamy just read into the record?" Ethan didn't answer right away. He glanced at Wayne, who gave the smallest, almost imperceptible shake of his head, the gesture of a lawyer who has run out of room to maneuver and knows it. "I want to consult with my attorney before responding further," Ethan finally said, and the easy confidence that had carried him through the entire hearing cracked down the middle like drywall, finally giving way to whatever had been eating it from behind. "That's your right," Judge Alvarez said. She turned to Nora. "Ms. Bellamy, to your knowledge, was the purchase price named in the petition to Bradbury and Vance based on an independent appraisal?" "No, Your Honor. Mr. Whitmore set the price himself and asked my firm to prepare the sale documents accordingly. I raised a concern after an independent appraisal valued the property nearly $40,000 below the price Mr. Whitmore had set. He told me it wasn't something Bradbury and Vance would look at closely since the funds would be going toward a residence for his son." Judge Alvarez was quiet for a moment, looking over the exhibit folder. Diane had submitted the trust correspondence, the co-trustee petition, the forensic accountant's report, the deed record, the email. "This court has also received and reviewed a report from the guardian ad litem assigned to represent the minor's interests in this matter," she said. "That report is part of today's record as well." She set the folder down. "This court will not approve the proposed custody stipulation today. Temporary primary custody will remain with Mrs. Whitmore consistent with the current arrangement, pending a full evidentiary hearing on the trust matter and a completed forensic accounting of Whitmore Building Solutions and Meridian Grove Consulting. I'm also referring the co-trustee petition to the probate court for independent review, with a hold placed on any distribution in the interim." Ethan turned to me, something between disbelief and fury in his face. "You knew about all of this." "I read documents for a living," I said. "You started leaving too many of them where they could be found." Nora sat back down in the gallery's shoulders, shaking slightly, the weight of what she'd just done, professionally, personally, clearly settling on her all at once. Whatever she and Ethan had been to each other, it was obvious now that she hadn't come forward to save me. She'd come forward because she'd finally understood she was standing on ground that was giving way beneath her too, and she'd rather step off than be buried in it. Judge Alvarez struck her gavel once. "This hearing is adjourned pending further review." I didn't feel triumphant walking out. I felt something quieter, the particular relief of watching a structure you knew was compromised finally show its damage in daylight where it could still be repaired instead of collapsing later in the dark on top of the people you loved. In the hallway outside the courtroom, Ethan caught up to me by the elevators, Wayne trailing a few steps behind, already on his phone. "You planned this from the start," Ethan said low, not quite able to keep the shake out of his voice. "The whole time you were agreeing to everything you were building this." "I was protecting our son," I said. "You'll have plenty of time to think about the difference between those two things." He didn't say anything else. He just stood there as the elevator doors opened and I stepped in without him, and that was, as it turned out, the last real conversation we had that wasn't conducted entirely through lawyers. The months that followed moved slower than the ones before the hearing in the particular way that legal aftermaths do. The forensic accounting took until February to complete in full. It found what the preliminary report had only gestured toward nearly $210,000, moved out of Whitmore Building Solutions into Meridian Grove Consulting. Over 14 months, none of it tied to any invoiced service alongside the pending, never executed request for the inflated property purchase. The probate court permanently denied Ethan's co-trustee petition and referred the broader financial pattern to the district attorney's office for review. Whether that becomes a criminal case or a civil one, or simply a slow, expensive unwinding through the courts, is still, as I write this, an open question. Wayne Carell withdrew as Ethan's attorney in January, after Ethan refused twice to provide complete records the forensic review required, and insisted on maintaining claims the documents no longer supported the kind of position an ethical attorney can't keep standing behind. Nora Bellamy resigned from Marsh & Kellerman that same month after the firm opened its own internal review into her undisclosed personal relationship with a client, a clear conflict of interest violation, regardless of what she had or hadn't known at the time she signed the paperwork. Looking back now, I understand she moved out of state sometime that following spring. I don't know what happened to her after that, and I've stopped trying to find out. Whatever debt existed between us, if any did at all, I think it was paid the day she stood up in that gallery. The custody matter itself resolved in December after the evidentiary hearing Judge Alvarez had ordered. Given the findings given Patricia Nunez's report, given everything that had come to light, the court awarded me sole legal and primary physical custody of Caleb with a structured parenting schedule for Ethan, the first several visits supervised, transitioning to unsupervised time. Once the financial investigation concluded that both his new attorney and mine agreed was fair, given the circumstances. Caleb still sees his father most weekends. I've never once told him not to. Whatever Ethan did, he is still Caleb's father, and I decided a long time ago that the version of justice I actually wanted didn't require me to take that away from either of them. 3 months after the hearing on a mild evening in February, Caleb and I sat on the back porch of the house on Larchmont Lane, the one that was still ours at least for now, and as far as I know will stay that way. He was working through algebra homework pencil tapping against the table in the particular rhythm of a problem he hadn't quite cracked yet. I was restoring a small water-damaged letter I'd brought home from the archive, tweezers in hand, working under a raking lamp angled low across the page. "Dad's new lawyer called the house again today," Caleb said, not looking up. "Mom, is he going to be okay?" I set my tweezers down and thought about how to answer that honestly, the way I'd learned over these months to answer almost everything with him. "I don't know exactly what happens to your father," I said. "That part isn't up to me anymore, and honestly I think that's how it should be. But whatever does happen, I made sure the court saw the truth before anyone could use you or your future as a bargaining chip. That part I do know." He nodded, chewing the end of his pencil, and went back to his equations. The porch light humming faintly above us, moths circling it the way they had every summer of his childhood. I looked down at the letter in front of me, a small tear along one fold, ink slightly faded, but the words underneath still perfectly legible once you cleaned away what time and neglect had layered over it. That's the thing about the truth in paper or in people. It doesn't usually disappear. It waits quietly under whatever's been placed on top of it for someone patient enough to look. If this story felt familiar, if you've ever sat quietly while someone assumed your silence meant surrender, I hope it reminds you that patience isn't the same as giving up. Sometimes the strongest thing you can do is make sure the truth has